refraining from the engaging in completely legal and legitimate forms of speech. We notice similar judgments in the context of revealing trade union membership and so on. We argue that Section 66A of the IT Act, which criminalized speech that is annoying, is a classic case of law that would exercise a deeply chilling effect on free expression. The Delhi High Court, in four judgments, all within the last 10 years, has directly recognized the impact of the chilling effect on the freedom of expression. Indeed, in Ramjit Malani versus Subramaniam Swamy, the court not only cited the Sullivan Doctrine, but read the Supreme Court case Rajagopal to have incorporated into the Indian law. The Delhi High Court observed if a person is under fear of being sued, he may not express himself freely on public issues, and this would chill the public debate. Speech is God's gift to mankind. Though speech, a human being conveys his thoughts, sentiments, and feelings to others. Freedom of speech and expression is thus a natural right which human being acquires on birth. It is therefore a basic right. Everyone has the right to freedom of opinion and expression. The right includes freedom to hold opinions without interference and to seek and receive and impart information and ideas, though any media and regardless of frontiers proclaims the Universal Declaration of Human Rights in 1948. The people of India declared in the preamble of the Constitution, which they have unto themselves their resolve to secure to all citizens liberty of thought and expression. This resolves the reflection of Article 91, 90 bar 1A, which is one of the article found in Part 3 of the Constitution, which enumerates the fundamental rights. Social media comprises primary internet and mobile phone based tools for sharing and discussing information. It blends technology, telecommunication, and social interaction and provides a platform to communicate through words, pictures, films, and music. Social media includes web based and mobile technologies used to turn communication into the interactive dialogue. Social media is the fifth estate of a democratic policy today. There is saying that the Gutenberg of invented printing machine triggered the French Revolution, and Zuckerberg, who invented Facebook, triggered the Arab Revolution or Jasmine Revolution. It is amply demonstrate the power and vigor of social media. Shreya Singhal versus the Union Government of India is a judgment by a two-judge bench of Supreme Court of India in 2015 on the issue of online speech and intermediary liability in India. The Supreme Court struck down Section 66A of the Information Technology Act 2000 relating to restrictions on online speech and unconstitutional on grounds of violating the freedom of speech guaranteed under Article 19 within bracket on a of saved by virtue of being responsible restriction on the freedom of speech under Article 19 within 2. The Supreme Court also read down the Section 79 and rules under the section. It held that online intermediaries would only be obligated to take down content on receiving an order from a court or government authority. The case is considered a watershed moment for online free speech in India. Despite the sale single verdict, FIR are still being registered across the nation under 66A of IT Act. It is deplorable. Sedition and contempt of court pose serious threat to freedom of speech. Both are the living fossils in our legal ecology. They should be left to their natural extinction. As Dr. Amartya Sen pointed out on his argumentative India is noisy country that entertain heterodoxy. Let our democracy flourish with open debates and free speech. Voice is life. and silence is death for democracy. Let our democracy prevail with its verbosity. Thank you very much. And thank you very much for giving an opportunity to attend this seminar. Thank you, everybody.
Thank you, Rajmohan Unnidan, Member of Parliament from Kasaragod constituency. Sir, it's thought-provoking, and you are really a tiger in giving a subject in a nice manner. And you are not only acted in a movie, it is called as a tiger, but you are a real tiger in Parliament also, and you are the real tiger in the national webinar also. On behalf of the Department of Legal Studies and the University of Madras, I thank you, sir, wholeheartedly. And over to Selvi.
Thank you so much, sir, for giving a whole different, insightful meaning of freedom of speech and expression. Thank you for sharing your precious thought. We are pleased to have you. Thank you so much, sir. Next, now I invite Sri Shanmuga Radeshwaran, IPS, former Inspector General of Police, to deliver the felicitation speech. He holds an MPhil degree in psychology from Department of Psychology, University of Madras, and he has obtained his BL from Madras Law College and ML from the Department of Legal Studies, University of Madras. He is a recipient of various gallantry awards, commendations, and appreciations. We are pleased to have you with us today. Over to you.
Thank you, Madam. A very good morning to all the esteemed participants and Honorable Sri Justice C.V. Karthikeyan, who has very lucidly delivered the inaugural address, and Honorable Vice Chancellor Professor Gauri, who has delivered the presidential address, and Honorable Member of Parliament Sri Rajmohan Unnidan, who has delivered the other special address, and Professor Dr. Venugopal, who has organized many such webinars, not only organizing webinars, but also organizes the current, interesting, and valid topics, which is relevant to the relevant topics, Dr. Professor Venugopal and Professor Dr. Rajshekhar, and other panelists and distinguished participants. It is indeed a very great pleasure to share this webinar with you. We all the distinguished and esteemed speakers have quoted already about the Constitution 19(1)A and IT Act 66A and other things. Now, the freedom of speech and expression, basically, psychologically, you take a person, a well-rounded development of personality of a person, not only for the political development, but for his own personality development also. If a person is restricted from his speech, from his expressions, then he won't develop into a fully well-rounded personality. Ever since the infant born, the mother teaches the expression for the child, and child also is innate for expressing himself. That is why the founding fathers of the constitutions has made there are 6 freedoms basically, which is a fundamental nature for the development of all personalities under Article 19, and the current topic lies on Article 19(1) subclause A. But anything which is unrestricted, anything which is absolute, it is not going to do a good thing for the person, also the society. That is why even in our ancient literatures also, it is said in a very simple one word, Amirdavam alavu kimirinal visham. So we enjoy freedom absolutely. It is not going to help build the society. So 1902, they thought there must be a reasonable restrictions in the enjoyment of the freedoms. The world question starts, what should be the reasonable restrictions? There only the gamut of discussions, debates, and legal questions all raises. Wills has said, if people are given complete and absolute liberty without any form of control, then that's the ruin of the society. So we all will agree there should be a regulations. There should be some sort of restrictions. But it should be, the object of the restriction should be with the aim of public interest or the social interest. Those days when the constitutions were formed, the social medias were not there, the electronic communications was not there. So the problems which would arise because of the electronic and the other medias, electronic form of various medias, WhatsApp, Twitter, YouTube, intranets. So these were not visualized. Obviously will not be, because that time it was not thought. Now, these electronic media forms changes the entire criminal jurisprudence. Now, previously, earlier days, the offenses committed, the person will come in person, he will be there, and there are a lot of changes in the policing also took place, because it's all earlier, it was a person oriented. Now, you don't know who is the person, but he commits an offenses, he invades into the privacy, he commits various form of this thing in the cyberspace. The identity is not known. Now, that is the peculiarity of the cyberspace. Now, in this context, our freedom of expression and our freedom to express what we feel, what we want to say, how much it should be allowed and how much it should be restricted, what are the inbuilt checks method. See, we have very well all the legal luminaries know the 66 have been struck down because it was said unconstitutional Article 19(1)(a). And observations are made in 2nd August newspaper also, it has come on that there are hundreds of cases are still lying or still being proceeded under 66(a). And the Honorable Supreme Court have made all the states and union territories into party to respond to that, and the matter posted and sub judice now. So I'm not going into much into that. But now, as a public order, as we experience in the field, this unfettered freedom of expressions sometimes create a lot of public order disputes also. All of you will know that in the southern part of Tamil Nadu, it is on the social dynamics of caste systems. Anything small said, immediately it will flare up another thing. Whenever any events related to the community or the caste has come, it's always we analysis have found that 1 month before the event, there is spurt of lot of messages in WhatsApp, lot of messages in the internet, a lot of messages in especially the WhatsApp and the cell phone messages, audio messages, which will like infuriating or sparking the communal feelings. Now, you don't know who has put it, you don't know how to regulate it, you don't know that there was an incident where an audio was put from Singapore. The server in Singapore, it was put. It has created for 10 days a continuous stir and continuous blockade of roads, continuous mobilizations of the various villages, and we have to intervene so many levels. So this small audio have created, and ultimately we have to find out it was from Singapore. It was posted on that. Now the question arises, even if we want to restrict also, how do we restrict that places from other places? This person has posted from Singapore. How do we as an enforcement agency, how do we restrict? How do the government restrict? Who is responsible? whether the networking platform is responsible. What is their responsibility? What is their duty? Even our constitutions, and when it enumerated the rights of the citizens, it also speaks about the fundamental duties of the citizens on that. See, any right, it has to got a corresponding duty also. Professor Dr. Gauri has correctly pointed out thing that awareness, he has said about the creation of the awareness of the legal duties to the school students. I would say also that for every citizens also, that creation of the awareness to be created. What finally, when we made this fellow to come and caught on that, this fellow was saying, I have casually posted, I don't know what this much of complications will come. We have been conversing with each other. One fellow challenged me, where can you put this audio? I said, I can put it audio, because I don't know, it was only myself and I was speaking. I didn't know that it reached so much places, so many problems it created. He was pleading that consequence, ignorance of the consequence. He may be correct, I may not be correct also. This is always 50% probability. He would have been tutored to say that, he would have been genuinely felt also. Many times the school students, especially when they put this type of offensive this thing in the social media, after when they interacted with them, why did you do, what made you to do this? And that they said, we don't know the consequences. Just for the playful, we did it on that, but this has created this consequence. But who has to regulate this? Whose responsibility is this? Whether the schools or whether the persons, see, in such age do on that. And also these sort of regulatory issues have come on that. Now that regulation also, when it is created, when it is come into conflict, or when it is interpreted, or when sometimes it is inappropriately used by the enforcers or the rulers, then the problem comes, the clash between the expressions, freedom of speech and expressions on that. So this webinar, we need to discuss with about what level of regulations, what quantum of regulations, who is responsible. Now these platforms which they man, they are not you cannot make them thoroughly. Now in this case, I cannot make the server, or I cannot make the handler of the server, I cannot make the company which handles on that also responsible, because they are sitting somewhere in US, they are sitting somewhere in UK, Singapore. So what is their responsibility when it has come into that, how the government, or what restrictions, what way they can be made accountable? Ultimately, it is this thing is. And another questions which is to be addressed is the privacy, right to privacy. Article 21 is very, very beautiful article. It has expanded, and one such right is given as right to privacy also. Now, as Justice pointed out, we have been discussing the webinar. This webinar can be recorded anywhere. This webinar can be seen anywhere. And similarly, what we send, what we converse, everything can be monitored. Now we come to know in the social media that, see, the another threat in the use of social media would be the use of artificial intelligence. This is a very upcoming, and see, any weapon can be used for positive thing and negative thing. Artificial intelligence is good in many ways, but this is being used for commercial purposes. Okay, so long as this commercial purposes it is used, it is well within the government, but it is used for some other purpose against any person, against anybody, then it is becoming an inversion. It is affecting the right to privacy. Now, what laws to control this? What restrictions to make this to be regulated? See, the company Twitter or WhatsApp, all are sitting in another country which is governed by another law. All of a sudden, they have said also, they have done also, our law doesn't permit this, so I'm removing you. Why? Well, then where is the question of your right to expression and right to speech? He is regulating you. If I express certain things, if he doesn't like it, he removes you suddenly, then he suspends you. Then what would be our regulations, legality, and what should we do to adhere to wherever the countries in which operating, to adhere to their local legal systems, their social control. These questions and these legal legal issues has to be addressed. And I'm sure this panelist in the coming discussions, all these things will be addressed. Social media prospects are, yes, now what we discussed today, it is all pan-India, we can see all the world over, we can see if it is used for the sharing of knowledge, it is used for the betterment, it is used for the utility, then the social media has high prospects, there's no doubt about that. But however, the problems are the younger generation, awareness and misuse. And like earlier, if you do in a print media, the spread is only to localized. Now you misuse the electronic media, the spread is immediate and widespread. So the damages which would cause to the society or the public order will be instantaneous. That is why we say it is become better. And the credibility, who holds accountability for the credibility of the messages, or credibility of the newses. One small rumor which has said this happened on that, it is immediately, it is flashed up without seeing on that and without going into what it is said and credibility, that immediate sparks the public order disturbances. All these things are the ill effects of the negative side of the social media. And also for anything, small thing, if you go immediately, everybody that take in the cell phone, like it was said, while you're traveling, while you're being, and you're also, though the IT Act provisions are there, without capturing and circulating will be there, but they take pictures in the market, they take pictures in the public area and circulate it. And when we catch them and ask them, they say, we don't know the legal provision. So the awareness of the legal provisions has to be made, how it should be made, how it should be popularized, then how it should be simplified, because in a very highly technical manner, if it put, it cannot be done. And also finally, the prosecution part of it, how the electronic evidences that justice also addressed that issue on that, though there are certain amendments made in the Indian Evidence Act and in this thing, but still the implementation and how to make it on that is a very great difficult process there on that. One such case is when we face a lot of difficulties, one famous doctor case, where that was a case, first case in the country to get conviction in the IT Act way back in 2005. While handling those cases, we have faced a lot of procedural difficulties in bringing into the evidences. So a lot of these legal procedural questions also may be addressed in this webinar. And with this, I end my facilitation, and it is really a wonderful, current, relevant topic to discuss: the freedom of speech and expressions, problems and prospects. Anything has got problem, anything has prospect also. So I thank Professor Dr. Venugopal for inviting and sharing in this webinar. I thank Dr. Rajshekhar and the Vice Chancellor also. And with this, my few thoughts and a few practical questions, which is put forth before the panelists and the August forum. Out of this, few suggestions may come very well, and that may be addressed to the appropriate authority through the university, which will able to help the government as well as the authorities concerned to better enforce, to have better and effective expression, and also at the same time to remove or control the ill effects of the social media. Thank you, Professor. Thank you, everyone.
Thank you so much, sir. It was a valuable insights for us. Thank you so much. Thank you.
Thank you.
Now, let's move on to the technical discussion. The first panel session is moderated by Dr. G. Rajashekhar, sir, Assistant Professor, Department of Legal Studies, University of Madras, followed by the second session, moderated by Dr. R. Venkatesh, Assistant Professor, Anna Center for Public Affairs for the Purnima Balasubramanian. She is a qualified company secretary and holds a master's degree in business law from the reputed National Law School of India, University, Bangalore. Currently, she's a company secretary of a reputed listed IT company. She is an empaneled artist of South Zone Cultural Center and holds an MA in Bharatanatyam. She is a graded artist of Doordarshan, Chennai. Purnima has performed several solo programs and was chosen as part of Tamil Nadu Iyal Isai Nadaka Mandam's talent promotion program the year 2006. Her performances have been telecasted in channels such as Makkal TV, Adal Arasigal and Sangam, and DD's Podigai Nadana Arangam. She has been invited as chief guest has to judge various events and has been a regular anchor for many programs telecasted in DD Podigai. Thank you so much, ma'am, for being with us. Over to you, ma'am.
Thank you. Hello, good morning, everyone. I hope I'm audible and I hope there's no problem in my video as well. So can someone give me a thumbs up regarding that? Am I audible, Selvi?
Yes, ma'am, you're audible.
Thank you. So it's my great pleasure to be part of this one-day national seminar about freedom of speech and expression in social media, its problems and prospects. First, I would like to sincerely thank the Madras University Department of Legal Studies, Vice Chancellor Sir, Mr. Venugopal Sir, and Mr. Rajshekharan Sir for giving me this opportunity to be a part of this esteemed event. My humble salutations to the guests of the event, Honorable Justice C.V. Karthikeyan Sir, Member of Indian Parliament, Mr. Raj Mohan, Department of Legal Studies officials, and other accomplished speakers of this event. Most importantly, I'm extremely glad to be amidst a young, energetic, brilliant, and talented group of individuals attending this session, because I think quite a few law graduates are also here. So I must first thank you all for taking time off from your schedule, because I do know that attending a webinar is a choice. When you need to attend a meeting, it's not much of a choice, but when you attend a webinar, you make a conscious choice to be here. So as rightly Honorable Justice Karthikeyan Sir said, this definitely has to be one of the greatest advantages of internet and digital media, bringing to your house whatever you wish to see on your screen with the independence and comfort, mainly the convenience of attending it from your house. Before beginning to present my content, I would like to kindly request the participants to make this an interactive session. You can always share your views and opinions by typing it out in the chat box. And remember to please be kind, because when things are off base, we tend to be extra courageous, which is one of the points we will be touching upon today. And I will try to make my session as brief as possible, because I think we have already exceeded the time. And though being an ACS and MBL, I would like to see this topic from a layman's point of view, because we already have several law experts participating in today's webinar to enlighten you about the legal aspects relating to today's topic. So I'm just going to limit myself to a layman's point of view and try to keep it light. And I will try to answer or discuss any opinions that you might type out in the chat box today to the best of my ability. With the Independence Day approaching, I feel that the department has very rightly chosen this topic for the seminar, because it is of utmost relevance to today's society and the happenings in it. See, though our nation attained freedom in the year 1947, which we have already learned through various schooling sessions, which has been drummed into our heads with several years of education, mainly because we should learn to appreciate the value of what we have. So if you even know that our constitution offers certain rights, out of which one is right to freedom, within which the freedom of speech and expression is also covered. But this phase, the freedom of speech and expression, has taken a completely different form and relevance today. Humans are known to be social animals. We like to roam in groups. We are largely, in groups. But in today's life, many of us are alone. So in this regard, I would like to share a small video which I came across, which impressed me, because today's life is exactly like that. So I kindly request the host to give me the sharing option so that I can share the video with all of you.
Yes, madam, you can share now.
Yes. this movie impressed me because this is largely what our life has become today. You know, social media is supposed to be a technology that facilitates sharing of ideas, thoughts, and information by building virtual networks. But this sharing word has become redundant. It is just flowing one way. And when people look at other people's profiles, they see pictures and they want to be as cool as them. So they try to do something which will make them look as cool as their friends. And they want to do certain things which are redundant, not necessary for the usual life. We would rather prefer to live the real life than the real life. That's how it has become. So social media creates virtual networks. Earlier, it was networks by assembling at festivals or going to places together. So that was a kind of physical network that we had. But this network has been completely carried over to the virtual forum by networking platform and communities. So by design, social media is internet-based and gives users quick electronic communication of content. So this content can be anything, right from personal information or documents or videos or photos. So users engage with social media via computer or tablet or a smartphone or a variety of applications. So this social media has the capacity to create unrest by virtual internet communication more easily than print or TV media. So even this webinar, for example, if you put up a status saying that I attended so-and-so webinar today, then your friends are bound to look at your status and wonder, oh, whether should I have attended this seminar? What is my friend going to gain out of attending this seminar? Probably some extra advantage. I should have done that or I should not have done that. So this actually wastes that person's time rather than putting in actual efforts. So it has the possibility to create unrest very easily. And it's extremely essential and important to status of not just an individual, but probably even the nation as a whole. Today, we don't actually wait to listen to Neeraj Chopra's victory in the javelin through next day newspapers or the 7 o'clock news on the TV. Even as he throws the javelin, you have live videos running on sports channels and apps. And the moment the spear hits the ground, you have live updates on your phone. And before the athlete even gets hold of the medal, you can see the entire contact list on your WhatsApp phone, putting up statuses about his earlier practicing sessions or his small age pictures or his photographs. All this even before the athlete gets hold of the medal. So that's how powerful social media is. It makes any content viral, any content that you choose to be viral. So it's necessary to be cautious about what to propagate. Whenever you post anything, you create something called as a digital footprint. It is a part of you, it is a part of your personality, it is a part of your psyche that you choose to leave online. It is information about a particular person that exists on the internet as a result of their online activity. Of course, there were many apps that came up to help with this, like Snapchat. I think a few of you must be knowing why the Snapchat's logo is that of a ghost. It is about the phantom policy of the app, which says that the user has the prerogative to choose when to make the pictures or the conversations that they send to the other person disappear. It can disappear just after viewing, or it can disappear after 24 hours. So the ghost emphasizes the phantom policy of the Snapchat app. But even then, even Instagram has stories. It disappears within 24 hours. But even then, I can always screenshot you. I can always screen record whatever you post. And today's statue that you get, or today's activity that you might post on social media, might not look very attractive to your employers or your peers 10 years down the lane. So we definitely need to learn how to balance freedom of speech with compassion and consideration for human dignity, most importantly. We see a number of fake profiles on every social media. I'm sure that the women attending this session would have gone through this at some point of time in their lives. There would have been so many unwanted messages or pictures from random profiles landing into your personal messages. So, and boys completely face a different kind of abuse, because there was recently an incident where a woman posted a content about a man being abusive, just to falsely accuse him, and this person was arrested, and then he was known to be innocent and released, but he had that employers check background profiles of sexual predators and any sexual offenses. So he ended up having difficulty in getting employment anywhere, and he had recently posted in his Facebook profile as to how much it is affecting him and his family. None of his friends wanted to be seen with him. None of his family members wanted to be associated with him, all for nothing except an information which got passed on virally. So most importantly, we should verify the veracity of a statement before we act upon any information. I'm definitely not saying that we should not stand up for justice, but any justice that cannot be verified should be verified first, and then we can definitely stand for that. So if you need to create a fake account to even compliment somebody, then you understand that it is morally wrong, and you do that. Another event that's been happening recently in Facebook is that people create false Facebook profiles of, say, Mr. X. A person creates a false profile of Mr. X and he replicates Mr. X's profile exactly the way it is, with all of his information, right from school, college, his pictures, and he gives requests to Mr. X's friend, who accepted thinking that it is Mr. X. And they make random conversations, small time conversations, and ask for not big amounts, but small amounts, which the other person has no problem transferring because they already know this person. So they ask for 500 or 1,000, and even they send messages like, "I'm stuck here. I'm without a cab. Can you please give me 500 rupees? I just want to get back home, and I will transfer it to you." Since we already know this person and the amount is quite small, we don't hesitate transferring it. But once we know that it is fake, it even gives a rise of question as to whether the conversation itself was genuine. If you don't even know whether the conversation you're making is genuine or not, then you can imagine the number of pictures or the privacy that is available to others from your Facebook account or your Instagram account. The online space is governed by the Information Technology Act, which you all know. The Act empowers the government to block, filter, and take down content from online. Government is also empowered to turn off internet access completely, which is known as internet shutdown. And India, unfortunately, has the distinction of being the country with a larger number of internet shutdowns. The intermediary guideline rules of 2011 also required each intermediary to publish terms of use. The huge paragraph which you blindly click accept to, many of us don't even know what it is. The terms of service require to prohibit the user from posting content that is grossly harmful, harassing, blasphemous, defamatory, obscene, hateful, racially or ethnically objectionable, or unlawful in any manner. But you see, a lot of people having smartphones nowadays, with demonetization becoming compulsory, and even vendors or shopkeepers, all of them have a smartphone, and with access to smartphone comes access to any kind of apps. So all these user policy, they will not be able to read and understand, and especially when it's available only in English. Section 79 of the IT Act, after amendment in 2009, provides that an intermediary shall not be responsible for any third-party information, data, or communication link made available or hosted by him. So it was actually the user who was largely responsible for the content posted by him. But due to end-to-end encryption of certain apps like WhatsApp, which you're aware of, there was no way of tracing content back to a particular user. So the recent Information Technology Guidelines for Intermediaries and Digital Media Ethics Code Rules 2021, which you would have all come across, is supposed to be an oversight mechanism to deal with these issues, such as, number one is persistent spread of fake news. This fake news, there have been several deaths actually relating to fake news. There were several lynching incidents that happened in northern Maharashtra, where a mob of 3,500 plus villagers gathered and killed agricultural laborers on the suspicion that they were child lifters. The funniest part was that no police station in that area received any formal complaint about missing children or kidnappings. So therefore, it led to a situation where at Maharashtra, at prominent public locations, the state government had to put up large boards cautioning people against believing social media rumors. WhatsApp keeps reminding users, so like Chetna has recently typed, it keeps reminding users to not, their messages are encrypted, but it doesn't remind the users to not forward unverified information or misinformation, as it is prohibited use policy. The acceptable use policy is available only in English, like we said, and there is no user conditioning as to what kind of messages are not acceptable. So like the Honorable Justice said, we can even start a rumor saying that the session has been recorded 2 days back and it's being telecasted today. So also there's no literacy training on the fact that the platform has rumors and information and how to spot them and avoid becoming a source of it. All of you at some point of time would have received this message that forward this message to 18 or 20 more people, and that's when you're going to pass your exam or achieve good things in life. So all of you would have gotten this kind of forward, though we at some point of time know that it is fake, it's a little bit fake, but we don't want to take the risk of breaking the luck. So we forward it to 18 or 20 more people, especially the elders in the house. There will be certain forwards saying that 12 to 3 is the time where there are negative vibrations, so it is better to switch off the phone, or it is better to put it in the aeroplane mode and all that. So it makes it very easy for the hackers to hack such phones during that time. So basically, there's no user conditioning as to what is acceptable and what can be forwarded and what is the source of information or misinformation and how to verify it. And definitely, yes, unnecessary things should not be posted on social media. So I'll be coming to that later. The second thing that this guideline concentrates upon is that abuse of platforms to share morphed images of women and contents relating to revenge porn or to settle corporate rivalries. So if you had noticed a while back, there would have been this sari challenge, black and white challenge, 10 years challenge on the Facebook, where you share pictures of yourself from the past or the best pictures of you. But you imagine this, when somebody perpetrates such a challenge, the person, and the worst part of it is that you need to tag 10 or 12 more people. So when you do that, it makes it very easy for the person who started the challenge to follow whomever has been tagged and to access their profiles and to get hold of their pictures. And it's good for those of you who have locked your profiles, but then again, it doesn't prevent from the original person giving you a friend request. And because you see them in the mutual friend list, you might tend to accept. And that again gives them an access to your profile and the pictures in it. So imagine what plethora of images or content of yours, your private details, that might be available online for users that you might not even imagine. So why do we do this? The pleasure principle that was exponentiated by Sigmund Freud to characterize the tendency of people to seek pleasure and to avoid pain. So Freud argued that people will sometimes go to great lengths to even avoid momentary pain, particularly at times of psychological weakness or vulnerability. So whenever you feel low, whenever you have not been invited to an event, whenever you feel that you've missed out on life, you have an existential crisis, this validation that social media gives, you post a picture, you receive a lot of comments on that, you post something that looks cool and you receive a lot of likes or compliments on that. And right now, in Instagram, the number of followers that you have, measures your coolness quotient. So people put it on social mode or the public mode instead of having it a private profile, because when it is a public profile, you tend to receive a lot more requests, and a lot more followers that you have, the more cool you are, right? So we almost literally live a lie. In the current form, these guidelines could undermine the principles of open and accessible internet and violate the right to privacy and free speech of users, especially in the absence of data protection law. So we have already noted that we are already in levels of exposure that we don't need to be. And these kind of guidelines without data protection laws could expose us to even more vulnerable risks. So this also leads to an erosion of the safe harbor protection that is given to the intermediaries under Section 79 of the IT Act. On receiving a court order or being notified by an appropriate government agency, the intermediaries are those who provide the social platform like Facebook, YouTube, or Snapchat, or any application. They will need to remove or disable access to information and any unlawful information as early as possible, but no later than 36 hours. The intermediary should also provide information and assistance to the authorized government agency for investigative or protective or cybersecurity activities for the purpose of verification of the identity. So basically what they want to do is they want to find out and determine who perpetrated the message first. Or for prevention, detection, investigation, or prosecution of offences under any law for the time being in force, or for cyber security incidents within 72 hours of receipt of an order. So these rules, which categorize intermediary as social media intermediary and significant social media intermediary, are based on number of users. But if you see today, almost every intermediary has a large number of users, a large number of accounts. So almost everyone is going to come at a significant social intermediary. These intermediaries providing messaging services should enable identification of first originator of information. But like the esteemed panelists and speakers have already discussed so far, if somebody perpetrates an information from outside India, it remains to be seen how they would regulate such an information. So it is said that these orders will be passed only for the purpose of prevention, detection, investigation, prosecution, or punishment of an offense relating to sovereignty and integrity of India, and the security of the state, or friendly relations with foreign states, or public order, or an incitement to an offense to the above, or in relation with rape, sexually exclusive material, or child sexual abuse material, which are punishable with imprisonment for a term of not less than 5 years. So additionally, they've also said that no such order would be passed in cases where other less intrusive means were effective in identifying the originator of the information. And the intermediary would not be required to disclose the contents of any electronic message. So why are we so much bothered about the social media though? I would like to conduct a small activity here. I'm going to be playing a few notification sounds, and I would like all of you to try to identify these sounds and type it into the chat box. So I just want to conduct an activity whereby I will discuss why we are so much bothered about this social media. Can you identify that? Were any of you able to identify the notification sounds?
Yes.
Yeah. Yes. So that's exactly from Facebook. So these kind of notification sounds are exclusive to apps, and they propagate us to actually look at the phone whenever we listen to them, whenever we hear them. This sound that pops up tempts you to take up the phone and look at it. So that's why people on social media are called as influencers who have a large number of followers. So that's exactly why we are bothered so much about social media. We have a lot of movies, series, like the recent one on Netflix being Control Z, where it says that the Wi-Fi of a particular school was hacked, and all the secrets of the students were available to the hacker, and the students went to any lengths to actually protect their secrets. But what could have actually protected their secrets was a little bit of discretion from their part. So everyone are definitely bothered about their own privacy. And other series like Gossip Girl, movies like Nerve, Unfriended, talks about the dangers of social media. But what about the power it has? So when you listen to those sounds, you were immediately able to associate it with Facebook. And when you listen to a Netflix starting sound, you were immediately able to associate it with Netflix. So that power of association that social media has can be tapped into something wonderful. It can be an effective marketing tool, a wonderful management tool. So things like email automation, where you actually check out a product and you don't want to buy it to come out at that time. So automatically emails drop into your inbox asking you that you have left behind such a product, so and so percentage is available for sale, why don't you just check out the product? So it keeps reminding you about the product that you have left behind until you make a decision to actually buy it. And chatbots. So when you go to a website, there is an automatic messenger box that opens and it asks you, so can I help you? In what way may I help you? So instead of, a lot of us have this hesitation to call up people and ask for details. So for those people who don't prefer such kind of communication, these chatbots are very, very useful in understanding what needs to be taken up from a site. And Facebook Messenger ads have been extremely effective in advertisements, because once you start engaging with the messenger, it creates the feeling of a personal conversation to a user, and it's known to boost up sales by around 60 to 80%. So any company, a listed company mainly, is required to have a compliance officer, a grievance officer. It has a big set of regulations like the SEBI listing obligations and disclosure requirements regulations, and so many regulations that SEBI has imposed upon it. When all that a person invests in a company is just money. But when you invest time, emotions, and a part of yourself into social media, I think it's definitely user discretion that has to be exercised when you do it. And the only takeaway that we can derive out of all this is that as users, it is within our power and discretion to effectively utilize the network that our thumbs and hands can create. So with great power comes great responsibility. I would like to conclude by saying that definitely it is a user discretion that has to be exercised while posting up any content. Remember that it always leaves a digital footprint which you can never wipe away from your life. I hope all of you had a nice time in today's session, and I would like to once again thank the Department of Legal Studies of Madras University and Mr. Rajshekhar for giving me this wonderful opportunity. I'm cutting short my presentation for want of time, and a big thanks to all the future staffs for staying connected with me. Thank you.
Thank you so much for the stimulating speech, ma'am. You hit the nail on the head by speaking about the other side of social media realities, and it was very useful and interactive. We all enjoyed the discussion. Now, moderator sir, Dr. Rajshekhar sir would proceed.
Thank you, madam. Thank you, madam, for your wonderful and nice presentation. So, Madam has explained the issues and challenges in the layman's point of view. And she has highlighted the values of the freedom, and she has discussed the relevance of the topic today and more in a technological manner, and she has touched the issues and challenges, and it is very nice presentation. She also equated the pain and pleasure theory by Sigmund Freud, but normally we used to, in law, in jurisprudence, we used to say it is a utilitarian principle. And she has made the speech in the hedonistic calculus manner. So it is really, Madam, it is useful to everyone, and the many innovative ideas you have given. And you have talked about Section 79 of the IT Act, which speaks about the intermediaries and how we can be safe in the cyberspace. So according to, from her speech, what I understood is, if we give minimum information or minimum inputs to the cyberspace, means really we will be safe. So it is so she has finished with the dialogue, stating that it is user's discretion. So when we give up our part, then we have to face many problems. So really thank you for accepting our invitation and be with us till this time, and has given a wonderful innovative talk, Madam. We will thank you for your nice presentation and for your gracious Augustus presence in this function. Thank you once more. Thank you for your valuable idea. Thank you.
Thank you, sir.
Thank you so much, sir. Now, let's move on to the second panel, ma'am. Professor Dr. Bisni Gopalakrishnan, Dean Faculty of Law at School of Indian Legal Thought, Mahatma Gandhi University, Kerala. She has 22 years of rich teaching experience. She has qualified LLM examination with the first rank with distinction from the University of Kerala in the year 1999. In 2005, she joined the University of Kerala and continued till 2018. Later on, she joined as professor and head at the School of Indian Legal Thought, Mahatma Gandhi University in the year 2018. She has published various books and more than 35 research papers in reputed journals. She served as a syndicate member of Mahatma Gandhi University till February 2021. She was the only sole participant from India to take part in the United States Department of State Bureau of Educational and Cultural Affairs Professional Exchange Program and International Visitors Legal Program in USA. Her specialization includes constitutional law, administrative law, healthcare law, intellectual property rights, and women laws, and so on and so forth. Now, over to you, ma'am.
Honorable Vice Chancellor of University of Madras, most respected Professor Dr. B. Venugopal sir, Professor, Dean and Head of Department of Legal Studies, University of Madras, respected Dr. Rajashekaran sir, my co-panelist, respected Purnima Balasubramanian. Thank you for giving me an opportunity to be a part of this national webinar. It's a great honor, and I'm very delighted to be a part of this webinar. And the topic that Dr. Rajashekaran sir asked me to speak on is to interact with exploitation of women and children in social media. Now, all of us are witnessing the fourth industrial revolution. So we have a lot of tremendous opportunities in this the fourth industrial revolution. We have a lot of opportunity for greater connectivity. And the technological innovations, including the artificial intelligence and the big data, are in front of us, and we are using it in a very large scale. So innovations have concomitant challenges also. Now, from a women and child perspective, the social media gives a lot of challenges. For example, it gives a lot of it gives challenges as well as it gives a lot of opportunities. Now, as far as the opportunities are concerned, from a woman and a child perspective, it involves political empowerment. It involves social empowerment. It involves economic empowerment. It also includes the financial empowerment. Now, again, it also includes the gender empowerment. Now, it also involves a lot of democratization of information and opening up of dialogues for interactions of ideas and informations. This is in spite of the fact that women battle a lot of access barriers, language barriers, and barriers of safety concern. Now, when we compare the traditional social media with the contemporary online social media, we can find that there's a little bit of difference, because traditional media, it was for broadcasting. The impact or the emphasis was on broadcasting. Here, the contemporary social media, we can find new avenues for dialogues being opened up. It's not only for broadcasting, but it is seen as an avenue for newer dialogues. So the intersection of social media poses very pertinent questions, which we have to discuss in this particular session. The first question: whether or not these platforms have become attuned to gender issues, including representation, safety, and security. Second, why are women unable to reap the benefits of social media? Third, to what extent current legal provisions ensure safety for women? And what can we do to make the social media more inclusive and safer for women? Now, the data from UNFPA shows that between 2010 to 2019, the number of people using internet have doubled. And women have increased their presence. Now, this is two important facets. The first one is that the geographical distribution. The internet penetrates the rural areas also, and the number of social media platforms is exponentially grown. Now, 2000, we have the Twitter and FB giving its presence. And these platforms have developed their own mobile applications, user-friendly and accessible technologies. And they have a significant degree of influence on the social, political, economic, and cultural life of each and every people, especially women and children. And we can find that, again, from the latest UNFP data, 145 minutes every day people spend on social media. So when we are using the social media in a very extensive manner, concerns about the issues of representation and imagery in traditional media comes out. Because we have an example from 1989 as far as the MTV is concerned. Now, from the women perspective, social media is actually a double-edged sword. I was talking about the potentials of social media, especially in the political, economic, and the other informative explosions and empowerment. But there is a gray side to it. And what is the gray side? Now, we have witnessed, we have seen hypersexualized models of femininity in the social media. And this hypersexualized models affect the mental, the emotional, and the physical health of women and children. Now, boys and men see how their bodies are being portrayed in relation to girls and women. They internalize this. They internalize the notion that success and attractiveness are tied to power and aggression. Now, second problem is that when women and men are portrayed in stereotypical ways, and this stereotypical ways reflect and sustain socially endorsed views of gender. The third one, think about the advertisements that has been that comes before each one of us through the social media. The advertisements contain depiction of relations between men and women and emphasize traditional roles and often normalizes violence against women. Now, when media reinforces power dynamics that degrade and harm women and make gender-based violence seems trivial, what happens is that it reduces the act of violence being reported, and it even reduces the men, the women, and girls to speak up, and rather even to report the offenses they have to face. And once the woman or a girl has faced an abuse, they don't trust the social media anymore. For example, out of 52% of the women users, they don't trust the internet and they don't give personal information in the internet. And another aspect is that we do have lack of gender-specific data. Now, when we talk of rights and women's rights, we should also have a lot of gender-specific data relating to social media platforms. Neither the internet, nor the Mobile Association of India, nor the Google has gender aggregated data. Now, for example, Twitter has a survey, and Twitter, it released a survey that is from January 2019 to February 2021. And it surveyed nearly 522,000 to 52 lakh tweets from 10 cities. And what it has found that 24% of the women, they use the tweet basically on the books and the current affairs, the celebrities and the social issues. And 20% they concentrate on the local and the international news. And 6.9 talks about the daily, their life and the personal, and 4.2 talks about the personal talks. Now, social media have helped the discourse around the toxic implications of sexualized power gain momentum. Now, if you just remember 2012, now each one of us will remember that there was widespread protest broke out in the social media regarding the incident that we call the Nirbhaya incident. The hashtags like Delhi Braveheart on Twitter were used by millions in support for ensuring justice. So online rage and street protest both garnered together and it garnered the global attention and compelled the government of India to take action. So we find that this is a positive aspect because the rape laws were being amended, the definition of rape was being revamped, the punishment for rape victims was revised, the stringent punishment for acid attacks, stalking, and voyeurism was being introduced. And again, in 2017, there was another campaign, that is, women launched a campaign on Twitter, Labo Kalle again, that is the 12% of tax on sanitary napkins. And as a result of this, the period tax was scrapped. So that involves the plus points of the social media also. But on the gray side, we have many more to point out. For example, the gender divide in social media. What about the gender divide? I was talking about the sexual images. And what about the gender divide on the social media? Inequities are right across as far as women and the girl children are concerned. The Lokniti CSDS, they have brought about a recent report. It says that the social media is being dominated by the upper caste in urban areas. And 75% of tribals and 71% of Dalits, they are not even exposed to the social media. And the Dalit women are subjected to double marginality. The cultural mores also plays an important role. For example, in 2017, there was a village council in Uttar Pradesh which banned women from using mobile phones. So what I'm trying to say is that women face whatever abuses and threats women face on the physical world, it is being reflected on the online spaces also. And women who have experienced this abuse or harassment have a sense of apprehension. And what they do is that they adopt their online behavior. Just as in the physical world, women has always been fine-tuned or programmed to be nice women. In the online media, what they do is that they just try to fine-tune their behavior and they self-censor their content they post. They limit the interactions on the platforms, and out of fear of violence and abuse, they try to recheck whatever they post. And actually, this is silencing and pushing women out of online spaces. Many times we have incidents where the abuses leads to loss of employment, the loss of societal status, especially when we talk of revenge porn, and again, it is also caused serious issues for livelihood. So the growing, we have to acknowledge the fact that women are dropping out of social media due to this particular abuse and harassment. Now, the Amnesty International in 2019, they have made a survey of elections in the election scenario in India, and they have reported that 95 female 95 female politicians these 95 female politicians, they had to face 1 million hateful comments. And 1 out of the 5 was really sexist comments. So, and the Indian political women, it has been pointed out by Amnesty International, they are substantially high abuse when you compare with the other counterparts in UK and US. And again, we also have instances when Twitter is accused of toxic trolling. And FB is also as being targeted or emerged as a hunting ground for fake profiles, which is being narrated by the earlier speakers, by the earlier honorable speakers. Now you have sexually morphed images. There are several cases of vulgar and obscene photos of victims linked to fake profiles. And this ostensibly caused a lot of violence and it caused a lot of victimization and extreme anguish for a woman. And whether we have to, each one of us is to pose the question within our mind, is social media safe for women and children? Now, we have witnessed several campaigns like the digital HIFAT, and but at the same time, we have to acknowledge the fact that there is no standard definition for online gender-based violence. So, and there is, we have to witness a robust arrangement between the social media platforms and the exact parameters of what a harassment happens, what is a harassment in online media, and actually who can be defined as a victim or rather a survivor. We ought to have a clarity regarding these two aspects: the exact parameters of harassment and who would be defined as a victim bar a survivor. Now, as law students, as researchers, as academicians, as faculty members, we are aware of the cybercrime, and we know what a cybercrime is, and we also are aware of the IT provisions and the provisions relating in the IPC, especially 354D. So again, we are also aware of the cyberbullying and cyber stalking and all the offenses relating to the offenses relating to that and the punishments. Now, here again, when we just recollect the IT Act and the IPC provisions, these provisions have a strict definition of gendered abuse, and whether the violent behavior and harassment, is there an act mechanism for the violent behavior and harassment so that the redressal mechanism can be controlled aptly. So again, coming to a recent data that is by the NICRB, it contains a comprehensive cyber crime reporting portal, and it also contains the complaints pertaining to cyber crimes. So it also have the NICRB also contains headline numbers and the facility to track the complaints and reports. So if we just look into the social media, for example, the Facebook and YouTube and Twitter and Instagram, they have options for reporting or flagging objectionable contents. These social media can also take appropriate action based on social media policy. But is there a synergy between the social media and local police? That is another question that we have to think. And the NCRB statistics, that is, it shows that in 2019, 81.9% of increase is there as far as the cyber crimes are concerned, and of which 5.1 relates to sexual exploitation. So if we just look at the positive sides taken by the positive policies taken by the government, we can find that the Ministry of Home Affairs, they talk of cyber forensic training labs, the hiring forensic consultants, then training the police personnel and the prosecutors and people from judiciary, setting up awareness clinics, and again, monitoring the matrimonial sites. And all these are positive initiatives by the government. And what are the follow-up plans? Now, when we talk of follow-up plans, do the users know where to lodge a complaint when she is a victim of cybercrime? Do the users have a basic awareness as to where to approach? And how many are aware that cyberbullying and harassment are also treated as crime? Our women and girls have assurance that their complaints are taken seriously? Now, further to worry all of us, the online abuse is taking different forms. For example, bullying, stalking, impersonation, revenge porn, image-based sexual abuse, exploitation, hate speech, non-consensus pornography, a lot of diverse a lot of diverse types of online abuse are taking place. And gender inequality in technology is irradiated on these different platforms. Just take the case of algorithms. Algorithms are not immune to gender biases. It can contribute to toxic cultures. Look, anonymity, mob mentality, the permanence of harmful data online, it may lead to women being constantly re-victimized. And from 2019, we can find that there are 26 million new users as far as the internet is concerned. And COVID-19 has hotwired this particular transition. Now, COVID-19 is being described as the first major pandemic of the social media age. And more than half of the women was under the lockdown conditions, and the usage has been raised from 50% to 70%. Now, if a woman has limited digital skills, what will happen? Because almost all aspects of our life, whether it is the classes for children, or whether it is collecting groceries or going to the market, getting appointment, telemedicine, whatever it has been ruled by the digital world in this COVID phase. Now, if we have limited digital skills, the more you're prone to abuses. And the ICT facilitated violence has spread under the shadow pandemic of violence. And the specific cases have been documented. For example, when we are taking part in a video conference, there are instances in which, pornographic videos or obscene videos are being shared. Then there are threats of violence and harmful sexual contents being spread across. And then Zoom bombing is also something which we are currently facing. So increasing online and ICT-induced violence, especially during this COVID-19, creates a lot of problems for women, because we are hampering the voice of women, and we are hampering the active participation of women. Again, we are creating barriers for women to be included in the democratic process. So during the lockdown phase, the first phase, that is from March to August, the world was moving into an online mode. And simultaneously, we found that an average of 135 offenses was reported every day in May 2020. And the cybercrime unit, that is, they made a survey from May to August 2020, and it stated that nearly 4,000 cases was being registered, out of which 24% related to social media harassment. And during this term, we can find that 278 accounts being blocked by the police, and out of which 140 belongs to the Twitter and the other social media follows. So the platforms have inbuilt mechanisms to report harassment and bullying. But this is all, in spite of all this, we can find the crime rate being increased. So for example, the Facebook, if we just take the example of Facebook, Facebook have it has partnerships with the organizations to reduce the sexual harassment in the platforms. It has also launched the digital fingerprinting and photo matching technology, and it also talks about the robust hate speech policy. And Twitter has also a section called Staying Safe, and it is also strict policy regarding the sensitive content. So basically what happens is that the gender inequality, gender divide, and the silencing and the fine-tuning which women face in the physical world, it is there in the online social media also, though in a different format. So we have a long way to go before we can even think of creating a safer online environment for women and children. So we need urgent measures, for example, especially strengthening the redressal mechanisms, increasing the public awareness. Because whenever a crime is being committed, we find that women are being very reluctant to speak up, to come forward. And again, when children are being victimized, we find that they're being silenced, just like the women. So increasing the public awareness, making them come forward and questioning the atrocities that they face, and definitely having a closer connection between the social media platforms and the local police, so that we can think of a more safer environment for women and children in the social media. Thank you, Dr. Rajashekaran sir, for giving an opportunity to take part in this national seminar. Thank you very much.
Thank you so much, ma'am, for discussing the contemporary issues, especially challenges faced by women on social media. It was both witty and informative. The statistics shows us the truth on our online platform. Your suggestions on safeguard of women and children is very thoughtful. Once again, we are pleased to have you, ma'am. Now over to Dr. Rajashekar sir.
Thank you, teacher, for the wonderful lecture. So really it is a impressive one, and the language she used is very lucid and very clear. So one thing I have to say about the about Bismi teacher. Bismi teacher is a really a researcher. I know her when I was in Law Academy itself. Teacher has conducted many studies, especially her specialization is with respect to right to health. Even during the period of COVID, both in Malayalam as well as in other news medias and in various other colleges, she has given wonderful suggestions how to tackle this COVID-19 situations. So one or two meetings, I have also got the opportunity to participate. Anyhow, because of her expertise in this research area, based on a scientific data, mostly a qualitative data, she has presented or discussed the issue in a great manner. She started with the shift, that is the roadmap she has given from traditional media to social media is very wonderful. And it is itself is explanatory that we are traveling in rough roads, and we have to cross many hurdles, especially with this gender-based thing. So she has started her speech with the empowerment of women with the thing called the gender empowerment, and then she has discussed this genders based on certain gender-specific data, and she has shown very keen interest in discussing the pitfall in the legal framework, especially with respect to this advertisement area. Though we are having the act called this Indecent Representation of Women Act, Prevention Act was there, yet we are having some pitfall. She has highlighted that also. Then coming to this thing, she has given various ideas. She has categorically divided his discussion based on the gender issue in the media, the accessing social, the difficulties or the problems that was faced by the women in accessing these social medias, and the legal framework, that is the security issues in this social area. So when I thought of making this topic, I thought that madam is the teacher is the right person to give these things. Then she has discussed these various cyber crimes in a wonderful manner, and she has quoted the data from the Amnesty International law. It itself, Amnesty International, it itself shows how she has researched the thing. Really, madam, your Google map has helped us how to make a research using a qualitative data. Really, it is a useful to the, I hope it is useful to the young research scholars and even as well as the faculties who are doing who are preparing for a project. Either it may be ICSR project or it may be what we call as this UGC project or whatever may be. So Madam also talked about this both the substantial as well as the procedural legal framework that has to be extended to safeguard the interest of the women in the social media also. Then gender-based violence, from the data she has said, gender-based violences are increasing day by day, even in social media like physical nature. So altogether, really, this she has explained, or she has focused, or she has highlighted the entire aspects or entire issues that was everyday, day-to-day life facing by the women, and she has given the novel idea how to come out from these difficulties, or how to solve these things, or how to break the barriers in accessing the social media by a women in a safe and secure manner. Really, we are much enlightened by your wonderful presentation, teacher, and that is the most of the data you have cited has given us an idea, and it has lead, or your presentation has opened $1 million questions and a humpty number of hypotheses for further researches. So thank you for accepting our invitation, though through phone. You have accepted, readily accepted, and even though there is a shuffling of deck, you have not least bothered about that also, and you have come with us and presented your idea. Really, we are benefited out of you. Thank you, madam. Thank you once again for enlightening these things. Thank you. Over to Selvi.
Thank you so much. Thank you so much, sir. Our next panelist is Professor Dr. S. Kandaswamy, Department of Public Policy, Law and Governance, Central University of Rajasthan. He obtained his LLB from its University of Delhi, LLM from Pondicherry University, and PhD from the University of Madras in the year 2011. He started his teaching career as an assistant professor at MP Law College, Aurangabad. Presently, he is the head of the Department of Public Policy, Law and Governance at the Central University of Rajasthan. He has published various books and research papers in reputed journals. Now, over to you, sir. Yeah, please.
Hello, good morning, everybody. Am I audible?
Sir, yes, sir, you're audible. Yes, sir, we can hear you properly.
First of all, I would like to give my gratitude and thanks to the VC of the University of Madras, Professor B. Venugopal, head of the department, and Dr. Rajasekhar, and all other persons who have been associated with me while I was there. So the topic allotted to me is directly related with the seminar that is crux itself. So that is freedom of speech and the social media and the problems and the prospects. So that is a freedom of speech, everybody knows, but many times the problem arises how to use the freedom of speech. So that becomes the question. So that is one side, freedom of speech is there, it is to be encouraged. Other side, it cannot be allowed much liberally also. So that is why reasonable restrictions will also be there. So particularly philosophically, when we are taking the philosophy of the John Stuart Mill, he says this, he emphasized these two aspects. So that is one first thing is silenced opinion does not contain the truth. So that is the problem. When you are not allowing the people to speak, you cannot get the truth. The truth is important for all other purpose to the whole society. So that means people cannot be made silent. Other thing, allowing the people excessively to the air. So that is you are giving the much freedom, then it will lead to giving you the feedback of false opinions. So that is why when many persons are meeting, so finally real opinions will not come out. So these two things, so that is finally, so that is fully incorporated in our constitution also in the name of the freedom of speech one side, and subsequently under Article 19 subclass 2, directly it is restricted. So that is the important thing. We have to look into this matter in these two aspects. So when freedom of speech comes into picture, so that is it is pervading through many media. So that is basically media, mass media. So now it becomes social media. So these are all simply the development, historical development by way of using the scientific development. Otherwise, basically in all those things, the general thing is freedom of speech only. So at the beginning stage, only some of the media, basically at the starting of the Gutenberg during the 1642, so that it was only the print media, whereas only Bible was printed for the first time. So after that, the many type of media. So the next comes the radio, and the third thing, television. So now finally, so that is internet. So this is simply the transformation and the accumulation of the media. Otherwise, still print media is there, radio is also there, television is there, even though everything is getting merged in the internet media. So at each and every stage, they were fulfilling certain special requirements. Even now also, they are used because of their special nature. For example, print media in the nature of the newspaper, magazine, journal, etc., still they are having their own views. So it is having the convenience of referring at any time and storing it, all those things. It is more convenient than that of the internet media. Radio is also still serving the purpose because still we are having some of the remote areas. So whereas that is other type of media is unable to reach. So that is why still it is surviving. Some of the technology, they are refusing to die. So in that category, radio is also one of the technology of mass media which refuses to die. So like that of the other type of some of the medias, like that of the print media also. Television occupied, even though becoming popular of the television technology, subsequently internet occupied the place. So now in the case of the internet, so now the matter becomes complicated. So now how we will regulate this internet? We are having regulations locally also, internationally also. We are having the policies. Beyond all those things, we are having certain laws also. But still, we are unable to fully control the social media. Even though they are giving the much opportunities, much easiness to interact with the people, there are much facilities, everything is there. But still, they are used also, misused also. So when they are properly used, there will be no problem. When they are abused, then actually the problem arises. Then we have to look into whether our laws are sufficient, efficient, or adequate. All these questions arise. So now the social media does not stop only with the particular boundary. So that is, it is crossing the boundary. So when it is going beyond the national boundary, our municipal laws or otherwise our national laws become helpless. So we cannot make the law which is applicable to outside our territory. But still, even if it is, we are making the law, it cannot be operated. For example, under the Information Technology Act 2005, the jurisdiction is the universal jurisdiction. So that is whoever may be the person, so from wherever he may be, if he has committed the cyber crime which is affecting our own people, so automatically Indian court are competent to try for them. So, but it is not practically possible. So that is the actual problem. So in these cases, So that is our jurisdictional problem arise, and again international cooperation also the problem. So that is all the countries will not that is make the cooperation. So that is yes we require. So that is also the another problem. We cannot control effectively as far as the social media is concerned, and they will exercise whatever may be the that is communication in the name of the freedom of speech. So what type of law exactly covers this? So that is the big question. So everybody knows obviously there is no specific law which either govern the media itself or social media, because we don't have the law, separate law to govern the media or mass media. So only whatever the things are available already in the constitution, along with the auxiliary laws, they are having many laws are there. So we will be simply discussing as a, that is a bird eye view only. Otherwise, it is not possible to discuss in detail. Many auxiliary laws are there. Certain provisions are there. Using that only the whole media is covered. The same thing is applied in the social media also. Then that of the mass media, the social media is having the problem of different nature, because it is crossing the border. Matters are coming inside our country from outside, and from within our country it goes outside also. In both the cases, particularly when any undesired activity is conducted, so particularly in the nature of the crime, so many type of crime, whether it is obscenity, pornography, so scandals. So nowadays the lotteries, so prices, you see, you cannot say any specific crime, whatever the crime occurred in the physical world, so that now also it is occurring using the social media as a platform or internet as a platform. So previously we were able to effectively control because it was within the territory, but now it is going beyond the territory and coming from outside the territory also. So there the problem is in cyber law, that type of problem is a big challenge, because we don't have any centralized mechanism to control that. So now when we are simply talking about the social media, so at least we have to know what are all the type of social media available. So immediately we can say this Facebook, LinkedIn, Twitter, WhatsApp, all these things, some 4 or 5 things everybody is popular, but actually it does not stop with that. There are hundreds of social networks are there. So that is, there are hundreds of media are there which are using the internet as a medium to act. So that is many times on the purpose base, we can classify into different categories. For example, when we say social networks, some of the popular things, it may be Facebook, it may be the Twitter, it may be LinkedIn, it may be the Orkut, it may be the WhatsApp. Like that, we can enumerate that. So that is only this much we can know. Usually a person, common person may know that, and he may use that also. But there are so many things which are not known also, which are not used by all, because it is area wise or country wise. That is sometimes they will use the particular that is networks or otherwise particular social media. But according to purpose wise, when we are classifying, so directly in social network, these things may be included. So what is the purpose of this social network? So that is which is helping the people and organization. So that is for connecting themselves and sharing the information. The information that is the objective is very good, but many times they are misused. Then only the problem arises. Other thing, particularly media sharing networks. So that is particularly, it may be the text, it may be the movie, it may be some short film like that. So in that category, there may be Instagram, Snapchat, YouTube. So all these things, particularly they are used for media sharing. So even that TikTok, so that is sometimes they are criticized, and sometimes they create the problem also. So that is a small movie type videos that will be uploaded, and anybody can see that. So in that case, YouTube, that is very popular. It can be many times used for the that is good purpose. But sometimes if you are propagating any obnoxious messages or obnoxious videos, so then the trouble will arise. So that also some special networks which is peculiarly used for media sharing, that is also there. And other type of network, they are usually known as the discussion forums. So like that of the Reddit, Quora, Dick, etc. So this is also a good platform for the purpose of discussions. So discussing in any type of a subject matter, which is basically essential for sharing the views and other things, if it is used in the proper way. Other type of social media is bookmarking and content curation network. This is also one of the good platforms in which that is some of the networks, Pinterest and Flipboard. They are there. Particularly, they can be used, they can be shared, saved, and a discussion can be conducted through that, and any recent current events that can be discussed. So these are all the some of the special social media. And other thing, particularly targeting the consumers. So nowadays it is a very obvious. So consumer review network. So Yelp is there, Zomato is there, TripAdvisor. So here, so that is some brands, product and services, they may be propagated for attracting the customers. Sometimes tourism, destination, all those things may be there. So in that way also, so that is they are useful. And there are certain networks which is specifically used for publication. So like that of the WordPress, Tumblr, Medium, etc. So here particularly, so for publication, so publication of the articles or any ideas or whatever it may be, so that can be a good platform. And other thing, social shopping network. So that is again in that also many network types are available. There may be Amazon, Flipkart, Polyvore, Etsy, Fancy, all those things, shopping networks. And other thing, certain special networks, particularly interest-based network. So that is people of a like-minded group. They may be having certain special hobby or otherwise a special interest like that of the sports like that. So that is a special interest can be shared along with that. They're like that of Goodreads, House, Last FM, all those things. So these are also there. And one more type of network is also there, whereas it is that is a free sharing of their thinking. So that is sometimes there may be gossip, whatever the people are thinking. So that is that can also be spread out. So there actually the dangerous thing may be there. So like that of Ask Firm, After School, so all those things. So it can be compared with that of the postmodernism philosophy. So that is everything is acceptable. So whatever you are thinking, you are right. It is good thinking only. Whatever you are behaving, that is good. No problem, because people will behave like that. So that is much liberalism, but that cannot be allowed to that extent. So that is some of the networks they are doing that also. So these are all the many type of social media and the social network. So how all these things are regulated, that is the big question. In a nutshell, we can say, so that is 90% of the freedom of speech that is regulated only by way of using the only one constitutional provision. So that is Article 19, subclass 1A. So simply that is a freedom of speech and expression, that's all. So that is, it doesn't mean you can speak and you can express. So that is anything else. Immediately, the Constitution itself restrict that. So that is Article 19, subclass 2. So in that specifically, so 8 type of restrictions are there. Of course, it is not enumerated. It is used in a continuous sentence only, but still we can classify that. So this is the thing. So exactly, yes, John Stuart Mill said, one side the freedom is given, other side the restriction is made, because both are essential. So now when we are going from where we are, that is learning this type of giving the freedom to the people, so that is at an international level. So that is the human rights documents, much popular documents, Universal Declaration of Human Rights, and other one, international covenant of civil and political rights. So all those things, of course, by the year they may appear as a letter to our constitution, because UDHR it is 1948, International Covenant on Civil and Political Rights it is 1966, but the draft were already available, so even before our independence. So that was the fact. So that is why, of course, so that is our constitutional makers, they were knowing so the values of freedom of speech and expression. So when we go through all these things, of course, all this freedom of speech and expression, they were mentioned in Article 19 in Universal Declaration also, in the International Covenant on Civil and Political Right also, in our Indian Constitution also. Whether it is coincidental or a deliberation, that we cannot identify that, but still, so all the Article 19 speaks about the freedom of speech and opinion. Of course, that at the international human rights instruments, they did not speak much about the restriction. But once when it comes to the constitution, so that is specifically reasonable restrictions are made. But as far as the American Constitution is concerned, somewhat rather than that of the reasonable restrictions, they have not mentioned the reasonable restrictions in the Constitution itself. Instead of that, that is, they were giving more emphasis to the freedom of speech and expression. And again, they have specifically mentioned the freedom of the press also in the Constitution itself. So that is the importance of the American Constitution, particularly under Article 1, that is the first amendment to the Constitution. They have given all those things more important to the freedom of speech, and again special importance to the press also. Usually at that time that was the press only was there. Now we can take it as all the type of mass media, but it doesn't mean so that is they can give excessive freedom. Of course, even though it is not mentioned in the Constitution, but still reasonable restrictions are made practically there also. That is the thing. And again, coming to our Constitution, so that is many times, so that is the freedom of speech, they are having different facets. So that is the important thing. Simply, it is not the two words, speech and expression. So how far it is extended one side, that is the most important thing. When we say freedom of speech and expression, what type of things are included, whether it is the basic print media or the mass media or the social media, whatever it may be, the single provision, constitutional provision will be applicable to all these things. So freedom of speech includes so the right to circulate also. So that has been discussed in many cases, particularly Bennett Coleman case, Indian Express case. On all these cases, the court was in favor, particularly Supreme Court was in favor of the media, because unnecessarily in the name of the freedom of speech and expression, it cannot be taken into a narrow view. It has been given the wider view. So newspaper can be without any restriction, it can be circulated. So that was the important thing. So it cannot be, circulation cannot be curtailed simply on the basis of by way of restricting the price, or by way of restricting the number of copies, or by way of restricting the number of pages. So whenever the government was trying to impose certain restriction on these lines, the court was in favor of the, that is newspapers only. So circulation cannot be, that is curtailed by way of the pages or by way of the price, etc. Other aspect, right to criticize. So many times that right to criticize, so that is becoming importance in the democracy is concerned, because without a criticism, so that is the government cannot function properly. Only thing is the government should have the maturity to accept the criticism. It can be through any media or even through by a single person. So this was fully recognized by the Supreme Court, particularly in the case of Kedarnath versus the state of Bihar. So that is unnecessarily the criticism cannot be curtailed. So even though we are having certain special provisions in the Indian Penal Code also, particularly section 124A related to sedition. So that is they're promoting the dissatisfaction towards the established government. You see many times that provision is invoked, but it cannot be the thing because you see IPC was the British law by the Lord Macaulay in 1833, implemented from 1860. So at that time, that was the necessity. Now, many times it is criticized now whether that provision is still required or not, but still it is there. And we have to make the balance. Court has to make the balance only. And again, so that is section 505 of the Indian Penal Code is also there. So that is it is a matter of propagating the public mischief. So that is whether to promote that is propagating among the defense personnel to make them to commit them a mutiny, or otherwise to promote any group of person to go against the particular community. So all those things. So that is it is a provision related to promoting the enmity or dissatisfaction with the government, etc. So that is also there. In that cases, it will be treated as the that is a reasonable restriction only. So that is beyond the grounds. So that is there are some restrictions in the particular laws also. So that also we have to take it into consideration. So it is right to criticize is fully part of the that is freedom of speech. So like that, the Supreme Court from time to time they are expanding the origin of the freedom of speech and expression. So that is having the most important, whatever may be the media. So we have to accommodate that. The constitutional provision will penetrate into any type of media. It will protect also one side. And again, right to expression or express beyond the national boundaries. You see, this was a very that is matter was included. So particularly in the Maneka Gandhi versus Union of India in 1978, you see right to express beyond national boundaries. So that was recognized. So now you see during 1970s, that is there was no internet in India. Officially, internet was launched only in 1995. Actually, it got development only after 2001. So even though at that time there was no this type of media, internet media was there. Even then also you see, so that is right to express beyond national boundary was also recognized in that case as a part of the freedom of speech and expression. And again, right to conduct the interview. So that is and the right to get information also. So all those things are treated as a part of the freedom of speech only. So we have to understand the freedom of speech, its exact boundaries, how far it is expanded. So then only we can appreciate the freedom of speech. So this is the one thing. So that is how more liberty is given. Constitution also protect, Supreme Court also protect, there is no doubt. So that is simply one side of the coin. So we have to see the other side of the coin also, how far it is restricted. So the very popular grounds, so that is everybody knows, so that is which is specifically mentioned under the Constitution is sovereignty and integrity of India, security of the state, friendly relation with the foreign state, public order, decency and morality, contempt of court, defamation, incitement to an offense. So even though these grounds are specifically mentioned in the Constitution, but there are corollaries. For example, here the obscenity is not directly mentioned. So that is, but obscenity is one of the important area, whereas the reasonable restriction is imposed. So that is why, and again, so that is giving the undesirable advertisement, immoral advertisement, or advertisements which are given with the purpose of cheating. So all these things are not directly mentioned here, but still the auxiliary laws, they are specifically dealing with that. And that laws are also playing as part of regulating the freedom of speech and expression. So other thing, the other important area which is covered, so under the freedom of the speech, so that is related to the privacy of the individual. So that is privacy and the media. So many times in internet, privacy becomes an important issue. So of course, that word is not at all used in the constitution. So some of the countries specifically they are using that word. International that is human rights document specifically use that word, including the Universal Declaration of the Human Right and the International Covenant on Civil and Political. So they have used the word specifically privacy of the individual, home, correspondent, etc. But in our constitution, that word was not at all used. Later on, only Supreme Court, by way of interpretation of Article 21, so that is, they have decided, so the privacy is also part of the right to personal liberty. So that was the thing, life and personal liberty. So that is only interpretation. So that is, it is the accommodated by the Supreme Court only as part of the, that is fundamental right. But here that become a big issue in the internet media. So that is the important thing. So that is how far it can be allowed. So many times the violation of privacy in the internet media is a big issue. So that is data theft, personal information. So nowadays it is conducted as a business. So privacy at the initial stage, it was having only the limited sense. So particularly when it was related to the body only. Later on, the court also made the liberal interpretation. So it will be extended to the data also. So it cannot be limited only to the body of the particular person. So that is particularly if you say voyeurism, so mainly it is related to the body. So that is we have included in our Indian Penal Code also section 354. So that is voyeurism is also now a punishable offense. So simply if you are guessing, so that is when the other person is engaging in the private activity, so it will be treated as the offense. So now even if you are seeing a particular girl or woman for more than 15 seconds, also it will be covered under voyeurism. So that is all these things, the foundation is the privacy. So now we have developed our law also to this extent. But what is the same thing when it is committed in the media, particularly in the social media? So there the problem arises. So how you will regulate? So that is, you can still apply the Indian Penal Code. So, but against whom you will apply? That becomes the question. Immediately the jurisdiction will become the hurdle. Investigation will become a problem, unless otherwise. So that is, both are located in the territory itself, within our territory. So then also all type of that is evidence will become a very big problem. So all those problems are there. So that is why, so that is implementing the laws available on the social media or upon the internet media also becoming a very difficult task. So many of the crimes are getting escaped because of this weakness of the investigative mechanism and the trial mechanism also. Both are weak because of the jurisdictional issues. So many times, many training problem and other problem also there to the investigating and adjudicating authorities. So that is the separate issue. But still, jurisdiction becomes the important aspect. So here, privacy, even though that is promoted under the International Human Rights Instrument and it is accepted, and now we are having a certain aspect of that law also. And it was also actually developed by the Supreme Court only, even before all these media were not available. So in that case, instant, that is particularly Khadak Singh versus the state of UP. So that is in 1963, Supreme Court 1295. So that was the one of the landmark case because the person, he was a criminal. So that is, he was, vigilance was made by way of knocking the door of the particular person during the night. So that was not accepted by the Supreme Court, that type of surveillance to that extent. So that is, that was challenged, the Supreme Court accepted that. You can make the surveillance, but it cannot be allowed to that extent. So that after that, the many type of privacy issues arise in other popular case also, R.R. Gopal, popular Nakiran Gopal versus the state of Tamil Nadu, particularly in the case of Auto Shankar case also. So that is even his private life was kicked out and it was published. So that is the court was not satisfied for affecting the privacy to that extent. So that is a publication can be made. So that is whatever it is public, whatever the matter available in public, that that is newspapers or the magazine can publish, but you cannot go in depth to the inner life of the particular person. So that was the thing, because that will be treated as affecting privacy. Of course, that can be done by way of getting the consent only. So that is only the possible thing. So in all these cases, so that is privacy also there. Now again, under the Information Technology Act also, it become a sensitive issue. To some extent, it is that is prohibiting. So particularly some of the crimes. So whether it is pornography, theft, or registers, electronic records. So some cases it is protecting, not the whole aspect, but still. So it will be that is a useful one, because that act, the history of that act was not mainly for making it as a full-fledged cyber law. It was emerged only for the purpose of electronic commerce during 1995. Ancestral model law was there. Based upon that, it was enacted. But later on, some of the penal provisions were included to protect the electronic records, privacy, all those things, some of the offenses, that is to prevent some of the offenses. So that is also one of the things. And the other area is, so particularly the advertisement. So that is through the social media. So here, so that is we are having the advertisement code also. And beyond that, there are auxiliary laws to prohibit a certain type of advertisement. So that is starting from the Indian Penal Code. So that is exclusively that is prohibit obscene publication, distribution, sale, etc. So that is a very basic thing. So nowadays it is pervading the internet and is conducted as a business. And other type of, even that is Indian Penal Code prohibit the lottery itself. So nowadays it is taking the other form, so prices. Suddenly the message will come to you, you got a price, and ultimately they will ask you to deposit some amount to hand over the price, and the every matter will be turned into a ugly one. So that is, you see, in 1868 itself, all these things were taken to account. Now this is equally applicable in social media also, unless otherwise we are having the separate law. So that is, we have to apply the already available law only. Of course, the law is sufficient, but implementation is the problem. So again, the other law is also there, Young Persons Harmful Publication Act. So which is that is instigating the young person, corrupting the mind of the young person and turning them towards violence or cruelty, all these things. So these are specifically prohibited through the act. Again, emblems and names prevention, the act is also there to protect the dignity of the emblems. So national emblem is there, and other type of names are used exclusively by the sovereign authority, that cannot be used for other commercial purposes. And drugs, magic remedies. So these are all the restrictions. You see, making any miraculous cure. Many times we will be seeing that type of message. Even in television also, that type of advertisement will be there. Actually, it is not allowed under the Drugs and Magic Remedies Act to that extent. So that is, it cannot be allowed. Advertisement is a freedom of speech. There is no doubt. Advertisement is certainly a part of freedom of speech. And again, it is a other side also, the right to information, under the Right to Information Act also. So people should get the information. So we have to communicate the information. People have to get the information. So both of the requirements are there, but still some of the things are made restricted. This is also one of the area. And again, yes, obviously indecent representation of Women Act, Special Act is also there. So that is also prevented. And prenatal diagnostic technique, Prevention and Misuse Act, that is also there, sex determination. So for that purpose, so during 1990s, it was a big issue. So that is, many of the clinic used to give the advertisement also, particularly in Maharashtra. So the situation was very ugly. So finally, the act was made. Many of the, that is, doctors, nurses, they were arrested also. Clinics were closed. All those things. So that is happened because of this act. And other big issue, now it is going on, transplantation of human organs. So transplantation, so it should be donated. So there are so many restrictions. But usually the mafia group, they will be taking it, conducting it as a business. So that is, they get the kidney and other organs for a cheap rate from the laborers and other things. They will sell it in the international market in lakhs and crores. So even now also it is happening. Of course, at a local level, so under this act, it is regulated. In this case also, many hospitals, that is, they were implicated under this act. Many doctors were also arrested. And again, Drugs and Cosmetic Act. So that is also one of the act which prevent the unauthorized advertisement. And Motor Vehicle Act is also there. So these are all some of the act, so which is making certain restrictions and regulations upon the particular individual or upon the particular person, those who are using the specific medium. So legally, in all these ways, the restrictions are there, the regulations are made, but still the matters are going beyond our hands. So that is the reality. And finally, so that is the policy is also there as far as the media is concerned. So exactly what is the policy of the government, union government, or otherwise sometimes it is referred to as the BJP media policy. So technically we got to take it is the policy of the government. So there also, as I at the initial stage, as I have told, so that is the philosophy of John Stuart Mill only. So here they are taking the part from, that is Vedas. Let noble thoughts come to us from all sides. So that is one thing. So that is, we have to receive the knowledge from wherever it comes. So that is the Vedic philosophy. So they are following that. So that is, they are giving the freedom of speech and expression one side, and simultaneously they are applying the Gandhian philosophy also. So that is what Gandhi said. So we can open our windows for fresh air, that wind should not wash away our house. So that is, to that extent we cannot allow. So that is, it cannot wash away our house. So the wind should come only through our window. So only that much we can allow. So this is exactly the policy of the BJP or otherwise union government. So here, in consequence of this basic idea, so that is mainly they are allowing the freedom of speech and expression to our own citizens. Of course, Constitution also emphasizes the same thing. Article 19(1)(a) is applicable to the citizens. Here they are very careful. The media, the ownership of the media shall be in the hands of the Indian citizens. In unavoidable circumstances, only up to 20%, so that is of the foreign equality of investment can be allowed. It is just up to only 20%. So that means, so it will be only in the hands of the Indian citizen only. Whatever the media available in India, that should be within our own citizen only. And again, they are emphasizing that Article 19 subclause 2 of the Constitution shall be fully implemented. So that is the emphasis in the media policy. So that is because one way they are giving the freedom, other way they are having extra carefulness upon the restriction also. So finally, so that is these are all the things related to the freedom of expression and how it is regulated, because there are so many auxiliary laws also there. So particularly internet regulations are there within our own country and outside the country also, like that of ICCN. So all those mechanisms are also there. So that is that will be only the guidelines. Many times when that such type of guidelines are not followed, so the remedies becomes difficult because of the jurisdictional problem. With this, I would like to conclude my discussion. Thank you for that is patient hearing.
Thank you so much, sir. Your remarks triggered new ideas that will benefit the legal community. The extensive discussion on constitutional and criminal law perspective with regards to current issues on freedom of speech and expression in social media was very interesting. The comparative analysis of American Constitution and other international instruments were enlightening. Thank you so much, sir. We are so pleased to have you. Thank you. Over to Dr. Rajshekharan, sir.
Okay, Selvi. Selvi,
Yes, sir.
then you invite next speaker, Dr. Sudesh.
Okay, sir. Okay, sir.
Okay.
Thank you, sir. Yeah. Moving on to the next panelist for the day is Professor Dr. V. Sudesh. Professor Dr. V. Sudesh is an alumnus of Bangalore University, Bengaluru. He completed BA LLB degree in the year 1991 and a master's in law in the year 1993. He obtained a PhD degree in the year 2005. He has overall teaching and research experience of more than 25 years. He has served as the officiating VC of Bangalore University, Dean of Faculty of Law, Chairman and Principal, University Law College, Bangalore University, Bengaluru. Now we are so pleased to invite Dr. V. Sudesh for the panel discussion. Over to you, sir.
Okay. Yeah. Thank you, Selvi. Good afternoon to one and all present in this webinar. My respects to the president of today's function webinar, Honorable Vice Chancellor, Professor Dr. S. Gauri. My respects to Honorable Thiru Justice C.V. Karthikeyan, who delivered the inaugural address. My respects to Professor Dr. B. Venugopal, who delivered the welcome address, and to all resource persons who spoke just before me. I'm very happy to share my views, thoughts on this topic, regulating hate speech on social media. Well, friends, much has been spoken about freedom of speech and expression. Professor Kandaswamy, just before me speaking, has very exhaustively dealt on the law and policy on freedom of speech and expression. Well, before I dwell anything on the hate speech, let me take your attention to a few developments that happened at the beginning of this year, when the Supreme Court, on a public interest litigation, sought responses from the central government and others on a plea seeking framing of a law to regulate social media platforms like Facebook, Twitter, and make them responsible for allegedly spreading fake news and hate speeches. Friends, on a public interest litigation, the court sought responses from Press Council of India, the News Broadcasters Association, and other bodies to see if possible to regulate speech on social media. Well, the plea before the court, while saying that reach of social media is much wider than traditional media, has also referred to some communal violence, few communal violences, violent incidents in this country where social media was misused. As all of us know, social media is a hotbed of toxic and hateful conversations. And therefore, to curb hate speech and fake news has emerged as a very critical challenge for not only government in India, but internationally for all governments, because it is impossible to technologically regulate the social media content. We have seen some time back how a terrorist, probably in the year 2019, live streamed the killing of some people worshipping in a mosque, probably in Christchurch, New Zealand. And that was a live spread of hate content through Facebook. That sort of an incident makes it necessary for us to discuss on this important issue of regulating hate speech on social media. Another development which all of you must have read about it or observed is the government has now released a new set of regulation that is supposed to hold social media platforms accountable against their misuse and abuse. The new digital media rules, which aims at tightening the government's grip over social media networks to regulate their content. The new regulation holds the administration of the social media responsible for whatever is posted on the Facebook, on the social media content, on the social media platforms. The message is very clear that follow the government's order or risk prosecution. You know, several people representing Twitter in India were issued notices. Our own High Court of Karnataka, Honorable High Court of Karnataka, heard one such petition and an anticipatory bail was given from arrest for something filed in a court in UP. So these are some of the challenges that we are facing today. Now, these are the challenges. What is the basic issue of hate speech, regulating hate speech on social media? It is agreed now, and since morning we have been listening to this, that no democracy can survive if its citizens do not have the power and the right to express themselves by word, written or spoken. However, this right to express oneself should be used responsibly without intending to cause situations of violence or conflict amongst people belong to different religions, race, ethnic groups, political views, etc. So in essence, free speech is a hallmark of any thriving democracy. However, it comes with its own set of implied and express limitations. Even with regard to the freedom of speech, whether it is online or offline, various international organizations, including the UNESCO, is of the view that free flow of information should always be the norm. Counter speech should generally be preferred to suppression of speech. Now, problem here is counter speech should not turn into hate speech. Hate speech, the problem here is there is no definition on hate speech. What is a good or a normal speech or a pleasant speech versus a hate speech? Hate speech can be said to be an expression that vilifies, condemns an identifiable group, which could be a racial group, religious community, political group, sexual minority, etc., which encourages and justifies causing of harm to the members of those particular groups. It involves more than simply indicating that you dislike someone. It is more than that. It is also different than simply teasing or ridiculing someone or shouting a malicious word at them in a single moment of anger or frustration. And if you look at the history of Nazi Germany under Hitler, there's so many examples when hate speech were used to trigger ethnic violence resulting in genocide. The case of Jews in Nazi Germany and the Tutsi community in Rwanda. So the number of innocent lives lost in these war-related events depicts the ugly face of uncontrolled hate speech indulged by the leaders at that particular time. Now, what we find is in India, the hate speech on social media has assumed new proportions. We are a country of multicultural, multi-religion. Therefore, the thread of unity that runs through the entire country requires frequent maintenance. Every now and then, with so many religions, languages, and cultures, it is often a task for everyone to agree upon a common platform. With the country being one of the most dynamic democracies of the world, its citizens are given right to freedom of speech and expression under the Constitution, which binds all of us. Now, the problem here is, how do we control hate speech? How do we define hate speech? In fact, in one of the latest developments in the year 2014, the Supreme Court, in the case of a public interest litigation filed by Pravasi Bhalai Sangathan versus Union of India, Pravasi Bhalai Sangathan versus Union of India, AIR 2014 Supreme Court. It dealt with the case where the petitioner prayed that the state should take preemptory action against makers of hate speech. Court was helpless because it could only act within the law that was available. The court did not go beyond the purview of existing laws to penalize hate speech, as that would amount to judicial overreach. And therefore it refused to entertain the petition calling for issuing directions to the Election Commission in order to curb hate speeches. However, the bench of the court took the view that there are already sufficient provisions in the Indian criminal and penal law to address such matters. And in order to define what is a hate speech, the Supreme Court noted with approval some of the observations made in the Canadian case, the Watcott case, 2013. Relying on Watcott case, the Supreme Court provided definition of hate speech that includes the following statements. If at all you may call it a definition. By quoting the Watcott case, the court said, let me quote, hate speech is an effort to marginalize individuals based on their membership in a group, using expression that exposes the group to hatred. Hate speech seeks to delegitimize group members in the eyes of the majority, reducing their social standing and acceptance within society. Hate speech, therefore, rises beyond causing distress to individual group members and lays the groundwork for later broad attacks on vulnerable that can range from discrimination to segregation to deportation to violence, and in most extreme cases to genocide. Hate speech also impacts a protected group's ability to respond to the substantive ideas under debate, thereby placing a serious barrier to their full participation in our democracy, is the quote which the Supreme Court quoted from Watcott case, from the Canadian case. Nonetheless, what the Supreme Court did was the Supreme Court took upon to do more on this issue and requested the Law Commission to examine the issue raised before the court thoroughly, and also to consider if it deems proper defining the expression hate speech and make recommendation to the parliament to strengthen the election commission to curb the menace of hate speech, irrespective of whenever made. All of you know the Shreya Singhal case versus Union of India. So the law stands there, which struck down Section 66A of the Information Technology Act. Now, what we can assume from the various decisions of the Supreme Court of India is that it shows that India follows a speech protective regime, like in other countries, like the United States. And the courts are extremely cautious in restricting Article 19 of the Constitution. The reason behind such a stance is the apprehension and fear of misuse of restrictive statutes by the state. So that is where we stand now. Friends, the growth of social media in the last decade has been nothing short of a miracle. Use of social media through its various platforms has boosted a dialogue between individuals and groups from all walks of life. Social media has provided in the past 10 years what that could not be done an era back. Now, families, individuals having WhatsApp groups are involving chats, and so, most of the time, discussions and debates. Internet encapsulation seemingly infinite. It is infinite availability. And it has the potential for diffusion of knowledge and educational exchange. That is the true value of social media that we must be using it for. However, we must also acknowledge and assess its reach for broadcasting of counter-progressive information. Often at times, this open and free dialogue has its share of difficult consequences. We have seen that. Open use of web space for addressing issues, voicing opinions, engaging in discussions can more than often venture into the space where people and associations espousing these opinions often lose the foresight and jump into certain conclusions which are not genuine. The problem with social media content is even when the content is removed, it may find expression elsewhere, possibly in the same platform under a different name or in a different online space. Another difficulty in regulating hate speech is its anonymity. Online anonymity can also prove a challenge in dealing with hate speech. And this cloak of anonymous, is often used by cyber bullies to bring down others, sometimes leading to heated online discussion, splitting into communities in the form of riots. Online, people are known to be more critical of their opinions to the extent where it becomes destructive in nature only because they have the option of being anonymous. That's the advantage, which people are misusing. The social media platforms are often being used to promote hate speech, endangering the very fabric, very fragile fabric of peacefulness. Hate versus peace is the debate. When does peaceful speech end and hate speech begins is a problem which the law has to identify and fix it. Hate speech relies on tensions which seeks to reproduce and amplify. Such increased use and presence of social media divides us rather than uniting us. It creates us and them. And with this increased use, it becomes imperative to understand its role in promoting peace and stability in the society. We have seen that in the last decade. The advent and the growth of social media platforms like YouTube, Wikipedia, WhatsApp, Facebook, Twitter, etc. There has been witnessed a sudden increase in a way of bigotry, spewing videos, poisonous videos, hate-oriented online groups, racist messages, targeting religious minorities, people of particular gender, LGBT community, people belong to particular ethnicity. I'm unfortunate. Even during the COVID-19 lockdown, during the first phase of lockdown, how in a particular city, people who were out to purchase certain essentials during the relaxation given during the lockdown, their photographs, their videos were taken, and they were condemned of being belong to a particular ethnicity, and they were condemned for spreading the COVID-19. How unfortunate. Though internet is an essential part of modern dwelling, the uncontrolled growth of social media is leading to an unpeaceful society. Therefore, friends, the Law Commission of India took upon itself, and in its 267th report of the Law Commission, there were several suggestions made. Suggestions which had international implication. The Law Commission of India, in its report, has suggested the insertion of Section 153C and 505A to IPC. Section 153C prohibits and punishes incitement to hatred on grounds of religion, race, caste, or community, sex, gender, sexual orientation, place of birth, residence, language, disability, or tribe by using gravely threatening words, either spoken or written, signs, visible representation. The phrase gravely threatening is very vague, as we understand, and can be misused. The proposed Section 505A punishes causing fear, alarm, or provocation of violence by anyone in public, intentionally or on grounds of religion, race, caste, or community, sex, gender, sexual orientation, place of birth, residence, language, disability, or tribe by use of words, or displaying any writing, sign, or other visible representation. What we find here is, in India, despite the existing laws, whether the Indian Penal Code, whether in the Representation of People's Act, or whether in the Protection of Civil Rights Act, these laws control hate speech on a platform other than the social media. However, I am of the opinion that these sections could be used to control hate speech even on social media. For example, under Section 8 of the Representation of the People's Act 1951, Section 8 disqualifies a person from contesting election if he is convicted for indulging in acts amounting to illegitimate use of freedom of speech and expression. So, illegitimate use of freedom of speech and expression through social media could be one ground for his disqualification. Similarly, Section 123, 3A and Section 125 under the Representation of People's Act prohibits promotion of enmity on grounds of religion, race, caste, community, or language in connection with election as a corrupt electoral practice and prohibits it. So we have the laws there. Whether it is the Cable Television Network Regulation Act 1995, whether it is the Cinematograph Act 1952, whether it is the Code of Procedure 1973, we find that we have enough laws to tame hate speech on the social media. Friends, while we speak about hate speech, we have to understand that any regulation, any control of hate speech by the government, by the court, may in effect control the freedom of speech and expression itself. And therefore, what is important is for us to understand, to regulate hate speech, we have to look at a wider picture of public order, of security of state, of disturbing the public order. As the court said in one of the earliest cases, Brijbhushan versus State of Delhi, 1950s case, where the court opined that public order was allied to the public safety and considered equivalent to security of the state. And this interpretation was validated by the first Constitution Amendment, when public order was inserted as a ground for restriction under clause 19, under Article 19, clause 2. However, in a later case, into 1966, in Ram Manohar Lohia versus State of Bihar, the Supreme Court distinguished law and order, public order, and security of state from each other by observing that in the context of hate speech, this is important. What did the court say? Court said one has to imagine three concentric circles. Law and order represents the largest circle, within which is the next circle representing public order, and the smallest circle represents security of state. It is then easy to see that an act may affect law and order but not public order, just as an act may affect public order but not the security of the state. So the standard applied for restricting Article 19(1)(a) is the highest when imposed in the interest of security of the state. So if you have to control hate speech on social media, the interest of the security of the state has to be seen, looked upon. Also, a reasonable restriction under Article 19, clause 2 implies that the relation between restriction and public order has to be proximate and direct, as opposed to a remote or a fanciful connection. With regard to controlling hate, regulating hate speech, the courts have said that what is a hate speech and what is not a hate speech has to be seen from the context and the content, the context in which it is made and the content of that particular speech. Well, to conclude my deliberations on regulating hate speech, let me say this. Let us understand that it is undeniable that the consequences of the narrative that takes shape on online platforms more often than not have real life implications. We saw this in the year 2018 when rumors about child traffickers spread regarding child traffickers on public platforms like social media platforms like WhatsApp, which led to a spate of lynchings in rural areas. It happened in Bangalore also around 2 years back, when suddenly on WhatsApp, people took someone's photograph and said he's a child trafficker, and he was actually a beggar who was lynched. And very recently, during the elections that were held sometime back in Delhi, certain words were used enticing the crowds to chant a particular slogan, a slogan which led to communal riots. So friends, fake news and hate content in India are primarily related to person's caste, gender or religion, which all of us know are very sensitive topics for most of us. The regulations to deal with the law, the regulations under the law are most of the time concerned with the local authorities, the police administration. In this context, if you look at the latest regulation to control the social media platforms by the government of India, is now under public scrutiny. People are responding, whether it is the Twitter or WhatsApp or Facebook. They have appointed Indian citizens who could take up any objections on hate speech and remove them from the public platform. However, it has to be seen, this restriction or this regulation has to be seen in the larger context of protecting genuine freedom of speech and expression. Therefore, my suggestions are that in order to control hate speech on social media, what is important is enforcement, legal enforcement. States should have in place laws that prohibit advocacy of hatred and take legal action only in the way very clearly defined cases allowed by international human rights law. There should be content moderation regardless of government regulation, companies all over the world have a responsibility to avoid causing or contributing to human rights harm. Therefore, content moderation by social media companies is an important part of the solution. And lastly, and finally, and most importantly, education is important. The most important way of reducing proliferation of hate speech and its impact can be through education. This is perhaps the most important intervention needed. It should be the first and the last method adopted by the companies and the governments. Legal enforcement and content moderation can only treat the symptoms of online abuse. It is through programs in schools, in colleges, in universities, in offices, public and private, through education. We as content users, we as people who read the social media content, we must be aware of the content in the social media, and we must educate not only our own group members in that WhatsApp or Facebook, but also the society at large in regulating hate speech. Law alone will not do much, because it is after much struggle that we had a constitution. It is after much struggle and thought process that this very most important basic right in a democracy, freedom of speech and expression, has been given to us with reasonable restriction. If we want, we should not lose this. We must responsibly use our right. I thank the organizers of this webinar for giving an opportunity to speak on a most important topic. I know we are running short of time. Lunch is approaching. Therefore, I've stopped exactly at 1 o'clock. Thank you very much. Thank you, Professor Rajshekhar. Thank you, sir. Thank you, everybody there.
Thank you so much, sir, for the enlightening speech. It was a rigorous discussion on the need of regulation of hate speech. Examples of genocide of Jews in Germany and crimes against humanity in Rwanda shows how the hate speech could cause an irreversible damage to the mankind if it isn't controlled or contained. The discussion made us to realize the fragile nature of social media and how it is used to perpetrate violence against vulnerable section of people in the society. We understood the seriousness of regulation of hate speech, which is a need of the hour, and how education could help us to prevent such crime. Happy to have you. Thank you. Thank you so much. So now we will break for lunch and we will assemble at 2:30 p.m. During the second session, we will share the feedback form and the certificate will be issued only after submitting the form. We thank you all for your active participation, and we are expecting you for the second session at 2:30 p.m. Thank you. See you all at 2:30. And kindly join in the same link. Thank you.